Hi, everyone. I'm Alex Osborne, the Vice President of Client Success at G&A Partners, and thanks for being here with us today. Today, we have a leading expert in labor and employment law joining us to share what you need to know about labor and employment law developments in 2026, including one big insight that you should really be paying attention to right now. And I am so excited for this discussion. Today, we have with us Alexis Knapp, who is an attorney at Littler, one of the largest employment law firms in the country, and a fantastic partner to G&A. Alexis and I are going to have a strategic conversation focusing on your needs as business leaders. And in this webinar today, you'll learn a lot. And here's some of the key updates that you'll hear in this conversation today that we have. We're going to talk about employment and labor law landscape, strategies for managing risks while supporting your team, best practices for compliance, and like I mentioned just a minute ago, a big insight that you should really be paying attention to. Now, we don't plan on this being a lecture or purely theoretical. Our goal is for you to walk away with smart changes you can start implementing immediately following this webinar. We're here to share knowledge and to support you. And if you have questions, please submit these questions in the Q&A feature of this webinar, and we'll try to answer as many of your questions as we can at the end. So let's get right to it. Alexis, welcome. I'm so excited to have this conversation with you.
Thanks, Alex. I'm really excited to be with you today.
Thank you. And can you just give our audience a little introduction into you and a little background on your expertise?
I'm a partner with Littler, and I have been practicing exclusively labor and employment law for, I think I just started my 19th year. And before that, I was in human resources for a number of years. So I think it's fair to say since the very beginning, I have been in love with labor and employment law and sort of all of the compliance issues surrounding it.
Awesome. Well, we are excited to have you, and the expertise that you bring is really going to help our listeners with what they can do now to continue their compliance and their labor and employment practices going forward. So let's just jump right into this. So, Alexis, here's my first question for the day. As you look at 2026, now I know we're already into 2026, but as you look at the horizon for 2026, what should employers be paying particular attention to today when it comes to this labor and employment landscape?
Yeah, there is a lot going on, Alex, as I know you know, and I know G&A's clients are aware. I could go a number of different ways with this question, so I'll just sort of think through some of the things I see coming across my desk most often. There is a lot of emphasis right now from both the federal government and the courts and lawyers who do this work on both sides on issues of accommodation with a particular focus on pregnancy. And that may not seem like news. Their pregnancy discrimination laws have been around since the 1970s, but the newer Pregnant Workers Fairness Act has really taken the world by storm here in the United States because of the enhanced obligations for employers to accommodate workers who are impacted by pregnancy, childbirth, and related medical conditions. We may get to talk about that a little bit more today as we go on, but the emphasis on accommodation overall, but in particular for workers impacted by those conditions, is all of the rage these days when it comes to not only making sure we're doing it right because we want to treat our employees right and we want to comply with the law, but also employees' expectations in that space. We're hearing a lot more from employees about their need for accommodation due to pregnancy, childbirth, and related medical conditions. And employers really need to make sure that they are listening and watching for those needs and responding. So I think PWFA, the Pregnant Workers Fairness Act, is a big source of where I spend my days, at least in the accommodation realm most recently.
And I definitely want to dive into a little bit more to that. But let me ask before we do, there was one thing that we talked about last year. And this was some key points that we discussed when you joined us a year ago. I can't believe it's already been a year. And some of those were enforcement priorities for federal agencies like the EEOC, the DOL, and some shifts that were maybe happening. So what were those shifts that we were focusing on then? And has that changed going into the new year?
Yeah, that's a great question. I certainly feel like since the change in administration early last year, It's easy to get lost in what's going on in the media about labor employment priorities and enforcement goals and objectives. The substantive laws that prohibit discrimination, harassment, retaliation in the workforce, those types of laws, the substantive wage and hour laws about who is exempt and non exempt and how people get paid, the substantive law is largely unchanged. But we've definitely seen a little bit of a shift in the things that the EEOC, for example, or the Department of Labor's Wage and Hour Division are paying close attention to. The Equal Employment Opportunity Commission is the agency, the federal agency that's charged with the enforcement of anti-discrimination, anti-harassment, and anti-retaliation laws. And we've seen a shift in their focus. For example, one of the big pushes is on religious liberties and religious discrimination and accommodation in the workplace. I think the agency's been pretty public about its focus in that space. There's been a lot of focus on this topic that we so commonly refer to as reverse discrimination. For many years, the concept, and it's not a term of art legally, but it's one that I think many people have adopted, that reverse discrimination is discrimination against a group that maybe has traditionally been in the majority instead of in the minority. But the reality is, in the United States, our anti discrimination laws protect anyone from discrimination based on their race, their sex, their religion, their ethnicity, their disability, and so on. And so it's not just particular groups or particular races or ethnicities or religions that are protected. And so the concept of reverse discrimination is a little bit of a misnomer because discrimination is discrimination. If someone's race is used against them or their sex is used against them, regardless of what their race or sex is, that violates federal and most state laws here in the United States. And so the EEOC has been educating on that concept and saying discrimination is discrimination regardless of what flavor it might come in. And as an agency, we're paying attention to all groups, minority and majority groups who are affected by unlawful discrimination. I think that's one key point that the EEOC has been big about. The agency recently revoked a prior anti-harassment guidance, emphasizing that it continued to be committed to rooting out unlawful harassment in the workplace, but taking away some of the examples that it believed were too broad and maybe went more to general civility in the workplace than actual unlawful harassment. So there's a lot of debate, and people on both sides of the political fence have different feelings about the EEOC's shift in priorities, but there's no question that unlawful conduct is still, obviously a priority for the agency. But I think some of the things we see the EEOC focusing on, particularly for systemic type litigation, where the EEOC is looking to bring litigation against an employer, definitely looking for sort of broader systemic issues. That's definitely a focus. On the wage and hour side with the Department of Labor, we see the Department of Labor reinvigorating its commitment to helping employers comply. I think for employers, it's really easy to feel that the agencies are very one-sided, and the agencies make every effort to be bipartisan, although I know on the enforcement side, it may not always feel that way for an employer. But I think the Department of Labor Wage and Hour Division is sort of upping its commitment to help employers comply. They've committed to improving and increasing their issuance of opinion letters, which went quiet for many, many years, where employers can ask questions of the DOL and get substantive answers about compliance issues that may not be very clear in the regulations or the case law. We see they've re-implemented their PAID program, which is a program that allows employers to sort of audit their own compliance and work with the Department of Labor to reach sort of a resolution of those issues, get those employees taken care of without maybe the danger of the penalties and the litigation and the investigation by the Department of Labor, sort of a collaborative effort to minimize risk once a compliance issue is discovered. The Department of Labor also issued just recently in February of 2026 its updated rule on independent contractor status. While the reviews are still mixed and we don't know exactly where that final rule will land, I think most folks believe that it's the Department of Labor's effort to make the independent contractor analysis a little bit simpler for employers, maybe a little more business friendly. We'll see where that rule lands. And then we also see the Department of Labor, sort of interestingly, taking a renewed look at child labor issues. And making sure that employers are complying with their employment of younger workers. So I think, once again, we're going to see that the substantive law, um, there haven't been any dramatic changes to the substantive law that the DOL or that the EEOC are enforcing. But I think we're seeing perhaps a shift in what they pay attention to and how they're spending their days.
Alexis, I love that. This going back to what you first said on the reverse discrimination, that is something that we hear all the time. I'm not going to say it's a buzzword, but we hear it often, right? And I appreciate your explanation of that. I mean, discrimination is discrimination and should be avoided, right? Regardless of the parties involved. And I love that explanation. Thank you. And as you then shifted over to the DOL, I know, as I talk to clients, all day, they often feel that it's a fight against them, right? And it's always, well, we're employee friendly and we're going to err on the side of the employee, right, in these situations. So I love to hear that they're kind of have this renewed effort to partner and to make sure that it is bipartisan, as you mentioned. I love that. And also the 1099 contractor designations. We have clients all the time asking about that, and I think that's fantastic that we can see maybe some additional clarity is kind of what I heard from you surrounding the 1099. So I love that. Thank you. That's great information.
Yeah, two things, if I could add, Alex, before we move on. One is, even though I think it's really encouraging to see the agencies trying to help employers comply, and we're looking for that as employers all the time, I do think it's really important for employers, regardless of their size and regardless of their industry, that before they engage with one of these agencies, that they are working with their outside partners, whether that means G&A or their legal counsel. It's critically important that employers make sure that those communications are exactly what we want to be doing and when we want to be doing them, and that those disclosures are guided by very able counsel, again, from G&A or from their legal counsel. We want to make sure that that partnership is there, because even with the agencies being more collaborative, their goal is, of course, investigation and compliance. And so as friendly as some of these changes may be from a business perspective, it's still important to make sure as an employer that you're getting good counsel before you're engaging directly with these agencies. And then I think the only other thing I would say quickly on the 1099 piece, and this is something I've heard for years in my role, you hear it all the time. There is this sense that if a business wants to make somebody an independent contractor, and if that person wants to be an independent contractor, that's all you need to make it happen. And that's just not how the law works. Even if this new rule is finalized in a slightly clearer way, in a way that might even be more favorable for businesses, the reality is the actual realities of those relationships will govern whether the law allows someone to be treated as an independent contractor. And someone being willing to be an independent contractor and an employer wanting them to be, and even a beautiful inked agreement between the two that this person is an independent contractor, will not win the day if the economic realities of that relationship don't truly show that that person's an independent contractor. And so employers who do utilize independent contractors should really, really reach out to your G&A partners and make sure that you are thinking through that, and make sure that you have a defensible path to treating someone as an independent contractor. Because even as the law becomes what we expect to be slightly more favorable, the reality of it is that the underlying relationship has to support that designation.
Yep. Alexis, such good points that, you want to make sure that you're checking yourself, right? Even if you think, utilize those experts that can back you up, and kind of that sound check for you to make sure on both pieces, right? On working with the state and federal agencies, and also on the 1099 designation, that you're just all buttoned up, because we don't want problems, right? Nobody wants problems. So no, I love that. That's awesome. Thank you. Well, let me ask one more question, back to maybe some changes we've seen from 25 to 26 before we kind of move on to continue our 2026 outlook. Um, there's been so many headlines recently about changes to the DEI programs at the federal level, and so from an employment law compliance perspective, is there anything that our listeners should consider for their DEI programs, assuming they have one? What should they consider at that when we're seeing kind of some federal level changes?
Yeah, that's a great question. It's another area where, to your point, if you watch the headlines, it's easy to get overwhelmed with what is permissible and what's not permissible. At the end of the day, lawful diversity programs that seek to expand the pool of qualified candidates are still entirely lawful. I think the focus that we've seen on diversity and equity and inclusion programs that have gotten a lot of media attention, there's certainly been litigation, have been programs that have been alleged to have included quotas and preferences based on race or sex or some other protected characteristic. And going back to that concept we talked about just a few minutes ago of reverse discrimination, the idea behind some of this litigation in the DEI space is against programs that are alleged to have had preferences or quotas based on race or sex or other protected characteristic, and therefore by definition may have discriminated against somebody because of their race or sex, even if that person was in a majority group. So I think it's really important to for employers to take a look at their DEI programs if they have those programs in place. It's okay to still desire and pursue a diverse workforce. Those are still great goals. It's just important that that is focused on outreach and expanding a pool of qualified people, and that the most qualified candidate is still chosen at the end of the day. And I think most employers are committed to that. I think employers who have not done so yet, it's a really good idea to work with your legal counsel to do a privileged review, an attorney client privileged review of those DEI programs, to make sure that any concerns that might be identified can be corrected in a privileged way. And then again, really just making sure that even managers and supervisors who are engaged in the hiring process and recruiting and talent teams who are engaged in that process understand the company's commitment to diversity, but also their commitment to compliance with the law. So I don't think the messaging should ever be that we're not allowed to pursue, embrace, and care about and advance diversity in our organization. We just want to make sure that it's not being done in a way that creates a preference for one group over another, which can create a discrimination problem across the board. So I think employers who care deeply about this shouldn't be disheartened by it. They just want to continue to shore up their programs like they do with any other compliance effort.
Yep. Such good advice, Alexis. I really appreciate that. And I know that'll ring true in the ears of many of our clients. And I love that. Thank you so much. Let me shift focus a little. Let's look now to 2026 and some of the key the key things that have been communicated and that clients are asking about. And one of those is AI. Right. So AI is one of those things that, we've all dabbled in it a little bit, depending on kind of where we're at. Some are gone heavy into it. Some just use it more as a search engine tool. But regardless of that, certain states have now put out AI legislation and some regulations. And you know, clients are always asking. In fact, just a meeting I had earlier this week, that was the big topic of our discussion with this particular client that I was speaking with was AI and how do we use it properly and let our employees use it properly and things like that. So I guess my question for you is on that AI front, what are some takeaways from an employment, perspective or employment compliance perspective, even for states that maybe don't have these specific laws about AI? What are you seeing?
This could be a webinar in itself, Alex. Whether I'm the expert to lead it or not is a different question, because I probably, like most people, feel like I'm scrambling to keep up with what's going on in the AI space in labor and employment law. I think, to your point, a lot of us are dabblers and we like to utilize it to learn things and explore things personally and professionally. But I think employers are finding they're a little surprised by the amount of legislation and enforcement and risk that comes along with things under an AI framework that would otherwise seem pretty simple and straightforward. One thing that pops into my mind is just the very simple, like AI note takers that you see pop up in Zoom meetings and Teams meetings and other sorts of online platform meetings, which seems so simple, right? Isn't it just a note taker? Isn't it just going to capture this meeting and then I don't have to take notes and then it's going to be more precise? But already we're seeing issues arising from these AI note takers. I think, first of all, there are federal and state privacy law issues relating to things like consent and whether the people that are involved know that the AI note taker is capturing notes. There are accuracy issues. There are sometimes assumptions made built into the technology where the AI tool is determining who's speaking. There are potential issues with with the technology interpreting accents, and someone from a different country or with a strong accent, or a speech issue that could be a disability. So we're hearing folks start to talk about, do we have potential discrimination type issues or disparate impact type issues that would come from the way that a technological tool is interpreting speech? Things that sort of blow my mind still, but that I'm still trying to get my head around. I think accuracy of information, worries that there are potentially confidential and privileged communications that are getting captured in a way that could later be viewed by others or discoverable by others. That actually, as a litigator for most of my career, one of the things that sort of blows my mind is what this is going to do to written discovery in litigation. And I hope that most of the employers within the sound of my voice don't find themselves entrenched in labor and employment litigation. But the reality of it is, when we get into litigation, all of those oral conversations that we've had that we may or may not have great memory of are now transcribed for all eternity. And just think about what that's going to do to the volume of litigation. So I don't want to be a naysayer about some of this technology, which can be fantastic and so useful and create so many efficiencies. So the message is not AI note takers are bad. I think the message is, let's make sure you understand and you're partnering with your vendor to make sure you understand how the technology works, maybe customizing it for your business and what you really do and don't want it to do, making sure that people who are participating in meetings where this AI note taker are consenting in a way that's compliant with federal and state law. I actually think there's so many interesting questions. I was also reading an article just recently and thinking about our talk today and kind of digging into the AI issue a little bit. There was a recent harassment case where I believe it was somewhere in the neighborhood of $4 million awarded to a plaintiff because of an AI generated explicit image of some kind that was circulated in the workforce that may have started out as a joke or something that someone was experimenting with technology. Just a really interesting space that we are sort of living in. I think one other thing I would say, without taking up too much time for AI, is that employers really need to be mindful of how they're using AI in ways they may not even realize to be AI. Something as simple as software that scans resumes and applications for employment and pulls out keywords and things of that sort. Is the AI trained and doing exactly what it should be doing, or are there potential discrimination issues tied into that? And I think we're increasingly seeing the courts and the agencies hold employers responsible for the responsible use of AI, regardless of whether they purchase it from a vendor. So it's not enough to just say, oh, we bought this software, right? It's really important that employers are partnering with the vendors to really understand, what are you screening out for? Are we really thinking carefully about job related criteria? And are we being expansive enough that we're not isolating groups of individuals who may be well qualified for the roles that we're recruiting for? So it's a fascinating space. I think I learn something new about it every day. And it's not something employers should be afraid of. I think they need to fully expect that their clients and their customers are going to want to know what they're doing with AI. And so we can't just hide from it. We have to deal with it. Employers should be looking at their contracts and their service agreements with their customers and their clients to figure out if their customers and clients have AI related expectations about how AI is or isn't being used. So I think it's a fascinating new world. It's not so new for some. It feels newer for me. But I really think it's an amazing space. I don't think employers should run from it. I think they have to learn enough about it to navigate in their particular business.
Yeah, Alexis, I couldn't agree more. I mean, it's a space that is, again, like you said, new to some, not as new to others, but generally new for the business world, right? And and guess what? It's not something that's going away, is it? It's here to stay. And so we need to, all of us, right, including, our business partners, ourselves, we need to figure out how we're going to embrace AI, and are we? Because I mean, to your point, things just such as easy as a note taker. How nice is that to not have to be jotting down all these notes and things while I'm in a conversation or in a meeting, but then knowing that those oral conversations are now written down and can be utilized, right? And so I think businesses and employers need to, I agree with you, figure out, well, one, what are the laws around it and what do they need to be aware of, but then two, how do they best use it for their business, because it really can be a benefit. But we need to be careful, and I love it. And to your point, it changes every day. I mean, I swear, one thing I hear today, in a week from now, is already going to be outdated because AI is moving just that fast. So it's such a fascinating world that, to your point, maybe we will have another webinar just on AI, because there's so much to talk about. So thank you, Alexis.
If I may, Alex, one other thing I would say in terms of the trending and the temperature that I've seen employers and how they're dealing with AI, I think, and this is a little bit of a general statement, but I think we saw a couple of years ago employers in some spaces prohibiting AI. We're
Mhm.
not going to do it. We're not going to use it. Nobody's allowed to use it. We don't use that in our business, making commitments to their customers and their clients that they weren't going to use it. And now, 2, 3, 4 years later, we see customers and clients going to employers and saying, tell me how you're going to do better and do more efficiently
Yep.
with AI. And so even that has just been such a change in such a short period of time. So again, I don't think it's something employers should run from. I don't think it looks the same in every business for sure. But I think having somebody in your organization that's sort of championing, what are we going to do with it? How are we going to use it? How are we not going to use it? Do we have policy? Are our policies updated to make sure employees know that their activity in AI is similarly governed by company expectations?
Yep.
So it's a really interesting space.
It really is. And you mentioned the efficiency, the optimization, the things like that can come from AI if utilized properly. And again, not every business is equal, right, in how they utilize AI. But you look at the technological advances in the history of business and the history of the world, and this is a new one, right, that we're moving into. And I think that business leaders and employees need to understand, well, how do I use it for me to advance forward, yet stay out of hot water, right? So such an interesting topic that fascinates me. Well, let's shift gears just a little bit. We've also been communicating with our G&A clients about a host of new paid and unpaid leave laws. I mean, these range anywhere from you have family illness to extended family illness that you may need to take off to help somebody, or going to donate blood, right? Something as simple and noble as that. Can you talk a little bit more about this new crop of laws? I mean, what employers should really be focusing on, especially those who maybe haven't been thinking about these new, paid and unpaid leave laws?
It is such a patchwork quilt of state and local laws all over the United States, requiring, as you said, everything from something like paid sick leave in a particular city or state to family leaves, which may be paid or unpaid, leaves for the meaning that could be the care of a family member who's ill. It could be for the birth of a child. It could be leave for something like organ or bone marrow donation. It could be for certain types of emergency responders who volunteer and do that kind of work. It can be school activities leave. It can be literally anything you can imagine. I think one of the challenges I see for employers, especially those who may consider themselves to be in the small and medium sized business space, I feel like sometimes if they have a major presence in one location, they feel like we're fine, we're good. We've got most of our people in this state and we kind of know what those rules are. I think large multi-state employers have been used to this for a little bit longer, and they've understood sort of the whack-a-mole that we play with all the state and local laws. But I think sometimes small and medium-sized businesses who have their primary presence in one location or two locations forget that they could have employees anywhere. They could have employees working remotely. They've got one person in New Jersey or one person in Colorado or a couple of people who work from home in California. And the reality that as the footprint of an employer expands, even sort of unintentionally, you are potentially bringing in obligations under those many state and local leave laws.
Mhm.
Another thing I see employers doing a lot, and I think in some ways it'll get you part of the way there, but not all the way there for compliance, is they assume their policies are so generous that it could never possibly trip over one of these requirements. So like, we offer a ton of PTO or we offer a ton of vacation, so we're going to be fine. And while that might get you there in, 50% of the locations where you have people, in the other 50% of the locations where people might be, it may not be enough. And it could be something as simple as how the time accrues or
Mhm.
how it's paid or the reasons that people can use it or whether they have to give advance notice or whether they need a doctor's note. Do they get it all at the beginning of the year? Do they accrue it by pay period? And so the multi-state realities, even for an employer who might mostly be based in one state or two states, is still something that employers must partner with their outside resources on. So I really encourage employers to work with your G&A partners team, work with your counsel, and make sure that you are double checking compliance in this space, because 10 years ago, there were a couple of these laws. Now there are more than 50. And that number might be too conservative. So really important to make sure you have a resource that you're partnering with on all of that.
Yeah, such a good point, Alexis. Especially in the last 5, 6 years as remote workforce has expanded, greatly. And we have so many of our clients that now have cl- you know one, two, or small clusters of employees elsewhere. That's so important to recognize that there are multiple laws, local laws, state laws, and all this other thing they have to pay attention to, even for the one, right? Even for the one that is in a remote place. And to your point, oh, don't worry, we give so much PTO or we have so much time off, we're good, we're covered. Well, to your point, is it accruing properly? Is it rolling over properly? Right? And all these other things that they need to be aware of. So I appreciate that. I think that is something that definitely business owners need to be mindful of every location that they have. And a location can be a single employee home location, right? Are they being compliant? So great information. Thank you. What a good kind of understanding of our current landscape, right? We've talked about some great things with leave and AI and DEI and all this stuff. Let me shift the focus just a little bit. I want to ask you a question that I think will help so many of our listeners, and that is, what's as you live and breathe in this world, what's one compliance mistake that you see small and mid-sized employers make over and over again, and how can we fix this?
I think particularly again in the small to medium sized business context, also for large companies and organizations, there's always a desire to minimize spend on things like outside human resources support or outside legal support. And I certainly understand that when you can do things with excellence internally, that's obviously a wonderful cost savings. But I do see employers sometimes resisting that investment early on and making errors or making decisions that sometimes impact them for the life of a matter. Simple things, or that may seem simple, like not getting either someone like their G&A partners team or their legal counsel involved when they've got a tricky termination situation, or they've got to do a reduction in force. And sometimes an employer may think, well, I have to do this reduction in force. It's a business need. It's not going to be unlawful because I have to do it. I lost the customer. I lost the contract. I have to reduce headcount. There's no question that the underlying need is lawful, but how you do it is incredibly sometimes legally cumbersome. Getting it done the right way and making sure you're providing the right documents, the right notices, that you're considering who's on that layoff list. So the underlying need may be absolutely defensible, but how you executed the layoff or the reduction in force has a lot of traps from a compliance and a labor and employment law perspective. Something as simple as responding to an unemployment claim. And G&A Partners does a wonderful job in partnering with its clients to sort of walk through some of these kinds of traps. But we respond to an unemployment claim. Someone gets terminated, they go to their state agency and they file a claim for unemployment benefits. And sometimes we're still frustrated about why they got fired. They weren't good performers, they didn't do a good job with our customers, our clients. And so we put a response in writing to that unemployment commission about why that person's no longer working here. And sometimes we do it quickly. We do it without asking the management team that was involved. We do it without looking at documents first. That story that we put in writing to the unemployment commission, that is the story we are stuck with forever. It can never change. If we end up finding ourselves dealing with an EEOC charge or another kind of government investigation or a demand letter from an attorney on the other side or litigation or all of the above, the reasons that we put down in writing in that unemployment claim can never change. They can never change. Otherwise, our reasoning is presumed to not be truthful. And so something as simple as slowing down, working with your outside partners like G&A, and making sure that you're thinking through employment decisions like terminations, reductions in force, um, you know, um, changes in your workforce to big things like pay and positions and how you're going to classify people as exempt or non-exempt, salaried or hourly. Those kinds of decisions feel like they should be within the purview of the business, right? I know what my business needs. This thing is happening. We've got to respond to it. There's no question that the business is the one who understands what needs to happen, but your outside partners are the ones that can help you make those business decisions you have to make in the most defensible and compliant way possible. And so, while I realize the goal is always to minimize spend and sometimes to some degree minimize outside involvement, and I can understand that, there are just certain things that have such significant compliance repercussions that an investment on the front end is absolutely one of your best steps to defense.
Yeah, I appreciate that. You mentioned slow down.
Slow
Take
down.
a breath. I love that, right? I think we can translate that into everything we do in our personal and business lives, but in this particular case, that's so important, isn't it? To
Yeah.
hold up, take a breath. Let's look at this. Let's maybe go take a walk if you need to. Come back, and then let's make sure we have our ducks in a row and we're utilizing our other resources to make sure we're answering properly. Because to your point, in that particular case, when we answer, it's stuck, right? That's what we're stuck with. You
That's
know,
the It's not very popular. I say this a lot and it's not very popular, but I'm going to continue to say it because it's true. The reality is that in the employment world, most decisions that we need to make don't necessarily have to be executed today. Now, we might make a decision to move forward. This is what we're doing, and we're moving forward, and here's how we're going to do it. But the implementation of the decision probably doesn't have to happen today. And it particularly doesn't have to happen today if we're not ready to do it in a way that is defensible and compliant. So, the G&A team, me as I work with my own clients, I'm always going to try and get you to the result. You're always going to try and get your businesses to the result they need to get to. But sometimes just pausing and, as you said, taking a deep breath and making sure we've got those ducks in a row makes that decision something we're not having to relive in litigation for the next 2 to 5 years.
such a good point. Such a good point. Let me ask another question around this same topic. Sometimes we hear a lot from our clients. Well, we let this person go just because they weren't a good fit, right? Weren't a good fit, and I understand and recognize that we should be documenting that a little bit differently, right? Than just wasn't a good fit. Can you expand on that a little bit for me and why that may not be the best reason?
Yeah, I think most organizations that are strong are committed to certain organizational values and organizational culture. They want to see certain things in their employees' performance and in their attitude and in how they treat their customers and clients or stakeholders. And that is all critically important. And I think if we're being honest, most of us feel like we can usually tell if somebody's going to be a good organizational fit pretty quickly after we hire them, right? We may not always be right, but I think within a few days, maybe a week, maybe a month, we get a sense from that new hire whether that person is going to be a good fit or not. Are they performing and working hard like we expect our people to work hard? Are they aligning with our organizational values and the things that matter to us here at this particular organization? Do they have the right attitude? Are they team players? Whatever those values are in a particular organization. So cultural fit is extraordinarily important. There's no question about that. But I think sometimes employers then use that statement as a reason for all their business decisions. And you can certainly imagine why, taken with outside of context, that can easily become a discrimination problem, right? So if I am terminating your employment and I feel like, you know what, it's just going to be a softer message. If I can just say you're not a good fit, it's not working out, we're going a different direction, you're not fitting in. That may seem like an easier message to convey. But the problem is, what does that mean to the one person on your team who might be different in some demographic way from others on the team? What does that mean to the only female in that department? What does it mean to the oldest worker on the team? What does it mean to someone who has non-majority in that group religious views or traditions that they adhere to? What does that mean to that person to say to them, "We're terminating your employment because you're not a good fit"? It means something very different than what was intended for sure. But the point of me bringing this up and thinking that this is so important is that softer messaging where you're trying to just let the person go gently is not entirely truthful and it's not entirely direct. And so making sure that those types of comments have context. If you are terminating employment for poor job performance, I would urge you to find a very gracious way to say that, to say that their job performance is not meeting expectations, or their attendance is not reliable, or their attitude is not consistent with what we expect in the treatment of our customers. Try to give an actual reason that isn't as amorphous as fit, because I think it can be perceived, unfortunately, in a very misdirected and discriminatory way, even though that was never what was intended. So while I understand treating someone with grace and dignity on the way out and trying to find a kind way to deliver a difficult message, just telling an individual you're not a good fit is, I think, very likely to get you some sort of a claim that your motives were very different than what was intended. So I am very big on cultural fit and organizational culture and people being good hires. I'm very, very committed to that, as most of the listeners are. But it's also important that you put some context around that and make sure that you're not using that as the easy way out. I also see that a lot when someone's a newer hire, maybe they're in the first 30, 60, 90 days of employment, and the employer feels like, you know what, it's just easier to tell them it's not a good fit. Same rules apply, right? The same anti-discrimination laws, the same rules that govern employment when someone's been there for 5 or 10 years govern those first 30, 60, 90 days. So fit is critically important, but you've got to be able to explain what the lack of fit is. Is it job performance? Is it attitude? Is it behavior?
Yep. I think that's critical, right? And you mentioned the directness versus being indirect, and somehow we sometimes deep down we're kind people, right? We don't want to fire somebody and make their day and their life worse, and we generally like people, and so I think we take that indirect step to soften it, as you mentioned, but that can get us into hot water, and it's not fair to the employee either.
That's right.
It's not fair to the employee. So thank you, I appreciate that.
Yeah, absolutely.
Okay, so magic question for you. So our as I talk to clients every single day, um, they have a varying range of what they're concerned about, right? Whether it's law, practices out there that are compliance practices, or whether it's growing their business, it's their employees, whatever it may be. But in your area of expertise, your labor and employment area, where are you seeing that employers are most exposed? And sometimes they think they're doing everything right, but they're exposed and they may not even know it. What is that? What does that look like for you?
You know, the first thing that pops into my mind is probably not the thing that most employers are going to think is the most exciting, but I would be remiss if I didn't say it out loud. Most employers believe that they are paying their employees and classifying their employees the right way. They intend to do that. They intend to follow the law. They intend to pay their hourly workers properly. They intend to capture overtime. They intend to make sure that they're calculating things correctly. Most employers aren't trying to not comply with those laws. They're trying to comply with them. But the wage and hour laws are probably one of the best examples in all of labor and employment law where there doesn't have to be a bad guy or a bad gal. There just has to be some compliance failure. And the laws, in some ways, I mean, these laws were drafted 90 years ago originally, right? And they've been updated over time. But I think in certain types of businesses, it feels like they haven't quite caught up with a service economy and much of the work that we do. Um, and the wage and hour laws can be very, very unforgiving about the way that people are classified and the way they're paid and how their time is captured. And I think one thing that's very common is an employer will do things like everyone else does. Or people will come from maybe a larger organization and they will come and open a small or work at a medium sized business. And they'll say, well, I'm sure this is fine because we did it at my big company. Or I'm sure this is fine because this is how everyone does it in the industry. The reality of wage and hour laws is that it's very easy for there to be compliance failures that you don't even know are there, that you never intended to violate. And it's often because we copy and we borrow practices from what other businesses are doing, especially businesses in our space. But what we see in wage and hour litigation is we see industry wide litigation where there will be lawsuits against large companies in a particular space. And once those lawyers discover that failure in a large company, they can copy paste that lawsuit against almost every other business in that industry because they know that those failures are copied and borrowed and passed down over time. So simple things, I shouldn't say simple because they can take time and energy, but simple, very basic things like partnering with G&A to look at how your employees are classified as exempt or non-exempt, or how you are capturing overtime or time worked by non-exempt hourly people when they're not at the office or at the work site. Time spent on devices, time spent traveling, calculating bonuses and how that impacts the regular rate of pay for hourly workers. Again, this is a lot of math and a lot of regulations and not everybody's favorite thing to dig into, which is why you have partnerships like G&A and like your attorneys that you work with. But critically important area where employers, they'll say things like, I'm never going to have this problem because I pay my people really well.
Mm.
Okay, let me just play devil's advocate for a moment. If you pay your people really well, that just means the damages in that litigation are higher. And I wish I had a different message, but it is possible to do this well. But it's not possible to do it well without checking whether you are complying. There are a lot of traps. And I found that each industry and each business kind of has its own traps. When I'm working with employers in this space, and Alex, you've probably had a similar experience, sometimes I'll find that certain aspects of wage and hour law are very easy for some businesses and very hard for others, and then vice versa, right? And so it really is just important to look carefully. And independent contractors that we talked about a few minutes ago is another area of potential risk. So wage and hour is, fun for nerds like me who love regulations and love math. May not be the most fun thing for an employer to dig into, but a critical area where there can be very significant financial liability, even when there's no bad actor.
That is that some, to your point, love digging into that, right?
Mhm.
And others do not. And others do not. Let me ask you about accommodations. That's kind of a hot topic right now as well, right? Accommodations and leaves. What what are you seeing that what's some proper documentation, policies, processes, et cetera, that our listeners should know about having those in place before accommodation requests arise? What should they know so that they can be prepared when those accommodation requests from their employees come up?
So accommodations, I hate to ever say that something is a flavor of the month, because that implies that it is fleeting. And it is, accommodations are not that. But in terms of just volume of what human resources teams are dealing with nationwide, the amount of leave and accommodation requests that are coming across HR professionals' desks is really like nothing we've ever seen before.
Mhm.
We talked a little bit about the multi-state leave realities a couple of minutes ago. We certainly know we're dealing with a lot of issues with FMLA and similar state and local laws. But accommodations have become one of the most voluminous things that we get in terms of inquiries from clients about how to navigate those. And I'm sure GNA has a similar experience with its clients. I think one of the challenges with accommodations, and it goes back to this question of things that employers may not even realize that is not compliant, is accommodations challenge the way we currently do something. By definition, if an employee or a candidate even is asking for an accommodation, they are asking for something that is different than the way we currently do it. And I think most employers, when they get an inquiry or request from a worker for something that we don't currently do, or that may even be against our current practice or policy, their immediate reaction is, oh, we don't do that. We don't have that, or that's not how we do it, or that's not the policy, or that's not our practice. When in reality, accommodation law requires that we do special and different things for individuals with mental and physical disabilities, individuals impacted by pregnancy, childbirth, and related conditions, and even sincerely held religious beliefs. And so we've got several categories of individuals who are entitled to be considered for accommodations in the workplace. And there is no rubber stamp way to get to the answer. There's no, these are the accommodations we provide, and these are the accommodations we don't provide. That is not a compliant plan. It's not a compliant policy. So employers really do need to get in front of this and be prepared for when that employee comes in and says, hey, I need an exception. I need help. I need something different. I need to do my work differently. I need a piece of equipment. I need a different schedule. I need to do my work somewhere differently or in a different order, or I need to sit down instead of stand. When employees come forward with those kinds of needs, employers need to have a process in place. And it's okay if you don't feel like you're an expert at it. It's okay if you're not sure what the answer is. It's okay if we have no idea because we've never done this before. But it is important that they are partnering with their friends at GNA Partners, or their in-house teams work to get together. What are we going to do when someone asks for an accommodation? Because we know we can't just say, we don't do that here. And even though we've got a policy, we can't just point to the policy, because by definition, accommodations sometimes require exceptions. So having a structure for how we're going to handle accommodation requests is very important. Some organizations may want an entire person or team that handles this. They have all of the forms and all of the documents, but that can be overwhelming for a typical small or medium-sized business. It's okay to just have a process that we point people to when they have those needs, and work with GNA partners or your legal counsel to make sure that you've got documents that you need. Do you have a form that somebody can take to their doctor? That's probably how we're going to get started. Have you mentioned accommodations in your policies? When you talk about things like equal opportunity and anti-discrimination, have you talked about, if you require an accommodation, contact human resources or contact the office manager? Or do we have a path? Because that's going to be one of the first steps that's really important for organizations to have, even if you don't have an entire framework of documents behind you yet, is to just say, hey, if something like this comes up, here's who's going to handle it, or here's who you should call, or here's how you get that ball rolling. And that's 9/10 of the battle, is capturing the issues so that when an employee has an accommodation, they've got a process to follow. And so I think, again, it depends how much you need in terms of documentation, and process is really going to depend a lot on on the size of your organization, your workforce, how many people are seeking leaves and accommodations. It's definitely not one size fits all, but you do need to make sure you have a process and a person, whether that's an internal person or a G&A partner, team member, that person knows, okay, this is how I seek accommodations. And maybe the answer is going to be yes, and maybe the answer is going to be no to the particular request, but we have to get there by going through the process that the law requires. So that's a perfect example of something that employers may not realize they're missing because there's not a process for employees to bring that forward. And we're seeing such a massive increase in charges and litigation in this space. So it's important to have a door that you can walk that person to, and open that door for them for whatever your process is.
It's so true. And you mentioned we're seeing that increase on our side as well. And so to have that process, that policy in place so that when that does come your way, you're not scrambling, right? That's key. I talked to a client just yesterday who had, I'm going to say this, it seemed like a silly accommodation request. Now I say silly because just the request itself, but it was not silly to that employee. It was not at all. And so I don't mean to discount that. I just mean the request, I was kind of like, oh, that's unique.
Yeah.
Right. But they had a process and they had a policy in place, and they had a point person, and they went through their process. They ended up accommodating this request, and it was of minimal cost and minimal, you know, uh, um, outcome to the client, I guess is what I'm trying to say, but to the employee, it was
Right.
huge. We've received a number of questions from our attendees, and we're so grateful for the questions that came in. We have run a little long on time because, Alexis, this has just been such a phenomenal discussion that we're only going to have time for one question. But we'll make sure we get back to all of you on the questions that you did ask. But the one question that I wanted to bring up is Thomas from Los Angeles asked this: I am hiring for a new role, and I've read mixed advice about how deeply I should look into candidates' social media profiles, even if they list them on their resume. Is there anything I should keep in mind or avoid? Alexis, this is a good one. Do you want to take that?
Alex, that is not a question. That is a webinar.
Yeah.
No, it is a great question. So thank you for that. Um, Social media use in recruiting and selection is certainly in a whole new ballgame than it was, 10 years ago. And I think we're also seeing the use of candidates sort of pushing themselves on social media. And to your point, sometimes even including their social media profiles on applications, on resumes, on CVs that they might submit to an employer for consideration. In some ways, it feels like if the candidate wants us to look, it's okay to look. And there's probably some truth to that at some level, but there are some traps that employers need to be aware of. First and foremost, there are some state and local laws that restrict what types of information can be viewed and considered and how that information is viewed. And that's something that you're going to want to make sure you navigate carefully. And perhaps the old employment litigator in me also immediately becomes nervous about potential discrimination issues and just the amount of information we could glean about someone's personal life. So while it may be easy enough to gather information about somebody on a professional networking site like LinkedIn, looking at other types of social media resources, and frankly, even LinkedIn as of late, sometimes gives visibility into things like politics and race and religion and sex and other characteristics that are protected by law. And so I think we have to balance what we're looking for against what we might get unintentionally, and being able to demonstrate that we made whatever decision we made to hire or to not hire for entirely lawful reasons. I strongly recommend that employers who are doing this, even if it's permissible under state and local law, even if it's something that you all decide as an organization adds more value than it does risk, that this be a centralized process and that there's someone responsible for it who is fully familiar with compliance obligations, and that this isn't something that hiring managers are just doing on their own. You really don't want this decentralized throughout the organization where people are like jumping onto each other's pages or following people on a particular social media site to try and figure out what they're doing in their free time. There are even off-duty conduct protection laws that say that employers aren't even allowed to consider certain types of things that someone might do, whether we like them or not, off duty if those behaviors or that conduct is lawful, whether or not we like it. And so I think it's impossible to ignore the realities of social media in recruiting. I think it's sort of like the AI issue we talked about earlier. I think maybe 5 years ago, employers were like, don't do it, don't do it. We're never going to do it. Now they're like, well, how do we do it well? So I think it sort of works the same way. So you definitely need to make sure that if you are utilizing social media information, you're being really thoughtful about what you're looking for on social media, how you're going to use it, who's going to see it, how you're going to share it, if at all, with decision makers, and making sure that the people who are doing the searching are doing it in a way that has an eye toward compliance. I don't think it's as easy as, well, they put it on their resume. I mean, if you think back, and Alex, you're probably not old enough to remember this, but I certainly am. People used to commonly put on their resumes that they were married or single and how many children they had and what their religious affiliation was. And so those things were on the resume, but it didn't mean that we were able to consider them in lawfully making a hiring decision. So social media, particularly for certain kinds of roles, you can imagine somebody who's responsible for developing content for your organization. My goodness, I want to see what they're doing on social media. If you're hiring someone in a very different role, is that information as useful and as defensible? That's a very different question.
Yeah. Such a great answer. One thing I wrote down here that is so key, that a takeaway for me, is having a centralized process for this, so that it's not even just the hiring manager, because you may have multiple hiring managers who are handling social media content in their hiring decisions very differently, right? And that can cause problems. But having that centralized process, if that is part of your process, right, to look at that for hiring decisions and other things. So thank you, Alexis. That's fantastic. Well, we've run out of time. Alexis, this has been an incredible conversation. Thank you for your insights, your advice, and your partnership. This has been such an amazing discussion, and I know that all of our listeners are feeling that same way. And want to thank all of you for spending this part of your day with us. We hope this webinar has been valuable, and hope it's been a good investment of your time, and that you have found some tools and resources and some good nuggets of information that you need to better protect your business and to support your employees. Now, we wish we could have gotten to more of your questions. We apologize we ran out of time for all the questions that came in, but we'll be sure to follow up with everyone who did ask a question to make sure that you get your answer. We'll also follow up with details about the continuing education credits for this webinar today, as well as more resources that we have to help you. After this, you'll receive a survey about how we did today. And if you don't mind, if you could take a couple of minutes to fill this out, we greatly appreciate your feedback. Feedback from you is how we make sure that these webinars are giving you the information that you need and that you want to help you grow your business and to stay in compliance. So again, we appreciate all of you joining us today. We thank you for your partnership, and we hope you have a wonderful day.